Ready when you are.
Thank you. Good afternoon. You've heard all the evidence in this case now. And you heard in Mr. Fields' opening statement, this case is about choices. This case is about the series of choices that Daniel Riley made on February 18th, 2023. Let's start with those choices. First of all, we know from the evidence he did not have a driver's license. He never had a driver's license. Yet, he drove a car that his mother rented, this Audi 5, knowing he didn't have a driver's license. Why do you need a driver's license? So you know how to safely operate a motor vehicle? So that you understand the rules of the road? So that you know what the signage means? You understand the dangers of driving a motor vehicle can have on other drivers and pedestrians? He didn't have that. He didn't have a driver's license. He never even passed the minimum requirements to have the privilege to drive in the state of Missouri, right? It's not granted that you can drive, it's a privilege. And you have to demonstrate that you can drive a vehicle safely. That's number one. Number two, we've got him speeding, right? We know that he got from 0 to 45 miles per hour on St. Charles, which, as you heard from Mr. Eckridge, who lives on that street, it's essentially an alleyway, okay? It's a one-way street. There are parked cars on either side, along with dumpsters, trash cans, okay? 0 to 45 miles per hour in 5 seconds. That's a choice. You saw on Tom Morris's, you heard from his testimony, and you saw on the gauges that were represented. That Audi is being driven at full throttle, pedal to the metal, 100%. That's a choice. Now we know that about a half a second before he approached the yield sign, took his foot off the gas for half a second. And then what did he do? Back down, pedal to the metal. And you know what? He had a yield sign. Why? Because it's a thoroughfare, right? There's other cars coming. The yield sign is, hey, slow down or stop. Be careful. Make sure you can safely enter this intersection. Did he do that? No. He didn't even yield. That was a choice. He just blew through it. It's a choice. What else do we know? We know from his blood draw that he had fentanyl, which the toxicologist testified can cause divided intention, such as driving, right? Your ability to react quickly, which you have to do when you're driving a car. He also had codeine in his system. And an effect of codeine is drowsiness and confusion. Okay? That's how he's operating that vehicle that night. Complete disregard for any other people that were around that night. And we know through every witness that testified It was busy downtown. It was Saturday of Mardi Gras. There were sports tournaments downtown. There were people on foot everywhere. And he's blowing through an intersection between Tom Morris told you that the speed at impact, the low end was 42.1 miles per hour, and the range at the high end was 66.9 miles per hour. Okay? That was a choice. That was a choice. What do we know? We know that you've got the young ladies, Ms. Gorman and Ms. Smith, and they're driving along in this white Chevy Impala, okay? They don't have any traffic signals telling them or notifying them that, hey, we need to yield or we need to stop here. They're following the rules of the road. They have the right of way, correct? They have the right of way. Because of his speed, they never saw him coming. He came out like a bat out of hell. Like Mr. Wissington told you. He was hauling ass. They didn't even have time to react. They didn't even see him coming. So, yeah, technically they hit him. But that doesn't mean that they are the ones who caused that collision. It was the defendant's actions that caused that collision. And as a result of that collision, he flipped over, and what happened? He crushed Janae Edmondson's legs between his vehicle and the parked car as she was trying to run to safety. Crushed her legs. That's what happened here, and this is serious, because I tell you what, but for this belt and the quick actions of her father, James, and Janae's will to live so she could see her parents again, and but for the grace of God, we would be here on a homicide today. Not because of anything he did or didn't do, but because of other people that reacted quickly. And a miracle, honestly. Now, I wanted to talk to you about the defendant's demeanor at the scene, okay? You saw some of the officers testify very emotionally. People who had, you heard from Officer Chop. He's a is for his own self-interest, and that's it. Now, we talked about consequences. We talked about consequences that Janae Edmondson had to suffer as a result of Daniel Riley's actions. She lost her legs, a perfectly healthy, athletic, bright, beautiful young lady in the prime of her life with the brightest future ahead of her. Not out of luck, but because of the choices she made in her life. And because of his actions, she now has no legs. She's suffering the consequences of the defendant's actions. And you know what she's doing? She's persevering. She's doing everything she can to continue to have the best life possible. Not because she's angry, but because she wants to move forward and she wants to have the best life possible. Consequences. That's forever. That's never going to change. She's never going to have her natural legs again. She's in the prime of her life. She was 17 years old when this happened. It's tragic. And it's due to the defendant's actions. No doubt about it. Now, I want to talk to you about the instructions in this case. I'm going to go ahead. The judge read you the instructions. Probably didn't make a whole lot of sense to you when he's reading it, but we're going to post them up here on the screen so that I can go through them with you to help you understand them, okay? Instruction number 5 relates to count 1, which is assault in the second degree, okay? So this is the law. I'm sorry, Mr. Deemer, can you move your bottle? Thank you. This is the instruction for assault in the second degree, and these are the elements, okay? These are the elements that make up the charge of assault in the second degree. First, on February 18, 2023, in the city of St. Louis, state of Missouri, well, there's no disagreement that it was February 18th, and we know that it was here in the city of St. Louis, downtown, right at St. Charles and North 11th Street, okay? Checked. That the defendant recklessly caused serious physical injury to Janae Edmondson by causing a collision in which she was struck, okay? So we've got some legal definitions there. First, let's get to recklessly. Okay. That paragraph there that starts, a person acts recklessly as to causing serious physical injury if the person consciously disregards a substantial and unjustifiable risk that his conduct will result in serious physical injury, and that disregard constitutes a gross deviation from the standard of care which a reasonable person would exercise in this situation. So how would a reasonable person have been driving down St. Charles Street under those circumstances? And ask yourself, and I submit to you, the defendant did not act reasonably. It was a joyride. He had a fancy car, and he was being a hotshot that night without regard to anyone else in the area. So reckless conduct, speeding, violating the yield sign, and not having a driver's license, more importantly. So now we need to find out through the definitions, what is serious physical injury, okay? serious physical injury in the last paragraph. It means physical injury that creates a substantial risk of death or that causes serious disfigurement or protracted loss or impairment of the function of any part of the body. Check that box. There is no doubt here that Janae Edmondson suffered serious physical injury. Zero. That box has been checked. All right? When you read the instruction number 5, you're going to get some verdict forms, okay? One is going to be for guilty and one is going to be for not guilty. I submit to you, based on the evidence in this case, guilty is the verdict form you want to sign. Because the defendant clearly, beyond a reasonable doubt, acted recklessly when he caused her injuries. Okay? Let's move on now to instruction number 6. Okay, number 6. Number 6 is an instruction that you would rely on if you found that he did not commit, that he was not guilty of committing assault in the 2nd degree, okay? This is a lesser degree of assault. This is assault in the 4th degree, okay? And I'm going to tell you right now, and you can see it in the instruction, the only difference here is that instead of recklessly causing serious physical injury, okay, it simply states that he caused physical pain. Now, you heard from that young lady and you saw her. That is, without question, serious physical injury. This instruction does not apply here, okay? Let's go on to the next instruction. Instruction number 7.
1 minute.
Thank you. Now we're talking about armed criminal action. We touched on this in jury selection, okay? First, you have to find him guilty of assault in the 2nd degree, okay? Once you've done that, you now go down and you consider instruction number 5. And what you're doing here is you're finding that the defendant committed assault in the 2nd degree by, with, or through the knowing use or assistance or aid of a dangerous instrument, okay? Here's the definition for dangerous instrument. It means any instrument, article, or substance that under the circumstances in which it is used is readily capable of causing death or other serious physical injury. Okay? We know that cars are dangerous instruments. Thank you, Your Honor. We know that deaths occur from motor vehicle accidents. We know that Janae Edmondson lost her legs by being crushed by a motor vehicle that was driven, I believe Mr. Edmondson said, like a 5,000-pound missile. That's how it was coming down the street towards them. That is a dangerous instrument, without a doubt. You're going to go to the verdict form for instruction number 5. You're going to have the foreperson sign guilty on armed criminal action, okay? Then the next 2 counts are essentially identical, only we have different victim names in there, okay? This is assault in the 4th degree, and this instruction is regarding Elizabeth Smith, and instruction number 9 is regarding Markia Gorman. This is assault in the 4th degree, which is that the defendant recklessly caused physical pain to each of these ladies by causing a collision with a motor vehicle in which she was an occupant. Okay, we know that. They had physical pain, fortunately not even close to what Janae endured. But we know they had physical pain. They had to go to the hospital. They got checked out. You're going to go to the verdict forms for 8 and 9, and you're going to have the foreperson sign on the guilty form, okay? Finally, the last one is that instruction number 10, that the defendant operated a motor vehicle on a highway in the 1000 block of St. Charles. He did so during a time when he did not have a valid operator's license, and that he knew or was aware that he didn't have a valid operator's license. Then, if you've met those elements, which we've checked all the boxes, you know about the record from the Department of Revenue, no driver's license, okay, no, none. Then you're going to go to the verdict form for instruction number 10, and you're going to find him guilty, okay? Now, Mr. Deemer's going to have an opportunity to speak to you, and then I'll get the last word because we have burden of proof in this case, all right?
Mr. Deemer?
Thank you, guys. This has been difficult. We appreciate your attention. I mean, at the very beginning of this case, when we were selecting the jury, I told you there was no doubt about serious physical injury. A lot of emotion wrapped up in exactly what happened. When she lost her legs, tragically, horrifyingly, that night, it put a lot of emotion into this case. But emotion is not mechanics. Emotions are not evidence. You have to concentrate on the evidence in this case to arrive at your verdict. They have to prove that Daniel knew that his actions were certain to do this. Not that they could, but that they will result. Not that they could result, that they will result under that instruction. To consciously disregard a substantial and unjustifiable risk that circumstances exist that will result. How do we know that that is a very difficult equation? Well, first of all, the same action in running the yield sign and speeding did not cause serious physical injury to Elizabeth Smith, nor to Micaiah Coleman. Well, if he knew that his consequences in driving that way were certain to cause that effect.
Your Honor, I'm going to object. He's misstating the instruction.
The instructions as they're written.
Please read the instruction, but the word will is in there, not may. It is will cause. Okay? Follow that logic. And what happened was 2 people got injured. They were hurt. The car, nobody knows how fast or how much energy that it was going to take. The car was lifted in that collision. When Daniel lost control of that car at that point, did he will it into somebody? Nobody wills that. Nobody wanted anybody to be hurt that night. Daniel didn't want that. Was he being a knucklehead? Maybe. Was Elizabeth Smith speeding? You know, we have to ask ourselves that question because we don't know. Because of the police work that has been done in this case, we do not know what she said. Oh, body cameras were on when they talked to Elizabeth. Nobody really knows how fast she was going. She doesn't remember how fast she was going. So we're going to rely on this box thing. We'll get to that in a minute. But the scientists, the experts have to rely to verify on stuff, what the physical evidence is, what the witness testimony is, to make sure that box is even right. She doesn't know her speed. Micaiah Gorman doesn't know. We do know this, that the woman with decreased vision never touched her brakes and hit that, and look at the pictures, with enough force to throw that Audi under one wheel when Daniel could no longer have control of that car. And by golly, by gosh, I wonder what Daniel knew about her when she was driving down the road. Did he know that some of those circumstances were, she shouldn't have been on the roadway either? Did Daniel know that there was a car that was parked against a yellow curb and that when she hit him with enough energy, it was going to spin him into a car and crush this woman? How is he going to know that? How is he going to know that those circumstances existed, that that result would necessarily follow? Again, look at the evidence in this case. What they needed to prove to you is what Daniel knew. They're trying to tell you that, oh, he must have known because he was so blase. No, they didn't use the word blase. Everybody wanted to say he was nonchalant. I wonder if and how they all chose that word. It's interesting that they all chose that word, that they were consistent in using that word. But was Daniel blase? No. What did he do after this accident? We had to find out from Micaiah that he actually came back. He came back to check to see if they were okay. That's what he knew. He knew he had been in an accident. And what he did was what a reasonable person would do. He went back and he checked on them. Did Daniel know that somebody was hurt there? No. Did somebody tell him later? Yes. Did you hear one police officer come in here and tell you that Daniel knew that it was his car that crushed her? Any police officer? One? More than one? No. Daniel has been cordoned off and shut off from the world. He had to borrow a phone from a stranger who doesn't appear in the report until much later. He had to borrow a phone from a stranger to get a hold of his mom and let him know, hey, I've been in a car accident. Can you get out here? I just, the car, whatever. He had to get a phone to do that, okay? And then eventually they arrest him and they kind of cut him off. And he's like, I've been cut off. And they're making a big deal about him worrying about a phone. Well, it's a critical situation because he doesn't know what's going on. No one has told him, other than a girl was hurt, how, in fact, she got hurt. He knew he was in an accident. Nobody said, hey, Daniel, your car is the one that hit that pedestrian. So when you ask him about being nonchalant, he is being told this entire time that he's doing 60 or 70 miles an hour. It may have been his perception that he was going slower. Maybe he was going faster. But it's his perception, and he did. Even the physical evidence. The EDR said he actually slowed down a little bit right before he hit that yield sign. A yield sign, by the way, that doesn't say cross traffic does not stop. What's in Daniel's mind when you see yield and cross traffic does not stop? Something completely different than yield. They're trying to say...
Objection as to speculation
This argument,
and subject to our motion in limine.
stay away from signs, except for yield signs.
All I'm saying is that signs give people information. Did Elizabeth Smith have a sign that warned her of perhaps a blind alley? That's what this is about. Consciously disregarding the substantial and unjustifiable risk that it will happen. So Elizabeth Smith, was she able to control it? Maybe, maybe not. I don't know how fast her car was going, but look at the front end of that thing. We got Travis Jones here to try and tell you guys that she might have been going a little bit faster. None of their experts want to tell you exactly how that Audi became airborne, other than maybe it was too stiff at that point, or some sort of mechanical nonsense. It's a car lighter than the Audi that sent the Audi into outer space. He got hit, not with a little bit of force, but he got hit hard enough that he blacked out. And when he kind of sort of came to, he checked on people. He didn't know he had hurt her. So here's the thing. When they're saying he didn't have any emotion, the emotion comes from knowing. You guys know what happened. That is the emotion of the case. Daniel can have no emotion for things he does not know. So to ascribe an emotionless Daniel to this situation is just wrong. And what witness came in here and said, oh, by the way, he was, high, and therefore he didn't know? No, that whole fentanyl coating thing is a distractor. They're saying he's a bad guy. He's made bad choices in the past. That's what that's about. It's not whether or not he was high, because you heard, not only did Stein say it, but Mark said it. If this kid had been screwed up that bad, if Daniel had been screwed up that bad, don't you think somebody would have said, follow my finger. Can you step heel to toe? Done something to verify that maybe he was high. No, it was just lucky they found out maybe he did something stupid, but we don't even know if it was him. I mean, you look at Chapo, okay, who doesn't wear his body camera conveniently when it's not the defendant on film, when they want to concentrate every camera that they have on the suspect. When he's interviewing those girls, no camera. But when he searches Daniel, he does it with his gloves on, and why? I'm afraid of sharp objects, I'm afraid of HIV, and I'm afraid of fentanyl. You touch it, it gets in you? I don't know. They're burden of proof. But again, he is not charged with being high. He is not charged with that. Again, that is a distraction for you guys to say Daniel is bad. It is character evidence, and it is nothing more. They have to prove to you what was on his mind that night. Was a kid pushing the gas pedal down and entering an intersection knowing.
Objection, that is a misstatement of the law.
Mr. Dean, stay away from the law unless you're going to say it right.
Is that person consciously disregarding a substantial and unjustifiable risk that circumstances exist that a result will follow? Not could, but will follow. It's an accident. A lot of things collided at that point in time to make it an accident. Was Daniel partially responsible for that? I don't know how you can avoid that. Was Elizabeth Smith? Well, I don't know. Let's think about that for a minute. What are some of the things that they took into consideration as far as holding Daniel responsible? Not having a driver's license? Well, Daniel told you, or actually told the officer, that he was trying to get a permit. And he had a permit.
Objection, facts and evidence.
Sustained, the jury will disregard and only recall the evidence about the inferences from the actual evidence.
If they're going to say he didn't have a license, what about Elizabeth Smith? You would say Daniel was speeding, what about Ms. Smith? You know, they're going to say Daniel failed to yield, did she keep a proper? You know, it is a tragic set of circumstances. Did Daniel want this to happen? Did Daniel think that, I know what I'm going to do today? I'm going to use this car as a weapon. He has to know. It has to be a knowing use of the car as a weapon. Not that it might become one.
Mr. Damer?
The instruction says,
Quote it right.
the instruction says knowing use. Knowing use. Not a maybe, not a could be, not a what might be. He has to know he is using it as a dangerous instrument. It is a knowing use, not a reckless use. Reckless is part of the assault thing. So again, let's evaluate what the state tried to put on you guys. You've got this guy named Moran who made mistake after mistake after mistake and bad sworn statements. And that's the guy that was out at the scene with his Leica machine doing these imaginary measurements, I guess, because when they did the recreation, they used that Leica, right? Everybody heard that. What disappeared in the Leica? A car that was on the scene? Wait, we're going to trust his measurements now, who doesn't even put a 4,000-pound car in the picture under the yield sign, right there at the corner, completely missed. Put that out of there. We're going to say this is his view and this is how fast he's going. Oh, wait, those measurements about that car and where everything was provided by a Leica. I don't know what that is. But it was Moran that was using it. And if it's Moran's information that went into that, what happened to that car? Are those measurements accurate? So when they're sitting there telling you how fast he's going, they need witness statements to say, well, she said she was 45. The EDR said she was 45, and the distance covered by the Leica is 45. What they don't have is a statement by her speed. What they don't have is evidence from the EDR that matches up to what? A reliable piece of information from that Leica? Measure twice, cut once. Measure twice, cut once. We know they measured it wrong because of what you saw. And therefore, what has Moran provided in terms of vetting of this accident scene? Was he able to vet it with a statement? Nope. Was he able to vet it with reliable information from a Leica? I don't know. I mean, if you want to believe Moran, that's your guy's choice. But holy smokes, guy gets there late in the evening, and I'm just kind of sort of trudging through this thing. Maybe, I get a statement from this guy named CJ. He says a black car, and over here I got a written statement, and I don't have to worry about that. We'll just move on. How many times did they interview CJ? I mean, CJ doesn't even know how many times he was interviewed. Their star witness, who was so wanting to make himself a hero. The former cop turned felon at the scene trying to make himself the big shot because he wanted to find the guy that fled. I'm looking in trash cans. I'm looking for the guy that fled from that car. I'm trying to make myself a... Hey, you need a witness? I'm over here. I'll tell you where to run. What? That's the hero in this case. All right? They give information, and that information is given to officers, and they say, you're doing 70. And Daniel's going, I ain't driving a Hellcat. That's what he's reacting to. I ain't driving a Hellcat. I couldn't have been going that fast. What Daniel knows is what they're telling him. Did anybody tell him she was hurt? Yeah, maybe. Did they tell him how she got hurt? Not at all. Did they tell him how fast he was going? 70. He says, I ain't doing 70. What's the matter with that? I mean, he's allowed to deny it. That's what he did that night. So you ask, well, what about this nonchalant attitude he's got at the hospital? Well, you heard what the cops were talking about. The police officers were talking to him about where he was and what he had been doing. They had taken the cuffs off him. He was talking to human beings. And he was asking, what's going on? I don't understand. I mean, she hit me, right? Why am I here? No, he said, Daniel, you're here because after your car got hit, you crushed a girl against the car. Maybe that would have made him say, well, holy smokes. I mean, you heard Bridget Fournier come in here. I said to her, Officer Fournier, when you told him that, you guys know where the girls come from, they went, huh, what? What girl? Oh, what? They didn't know. This Trent guy that's, he didn't know. But whoever Trent is, I mean, he's not there originally. Shows up later. But, more importantly, Daniel didn't know. And they want to make a big deal about Daniel and his phone, but, hey, Janae's mom was in a panic too. She's in a bad way. She wanted her phone. I'm a 21-year-old kid. I want my phone all the time. I'm a 62-year-old man. I want my phone all the time. If I don't have it, my life is in shambles. So here's the thing. Are they making a big deal out of that phone? For what reason? It's a lifeline. They're putting him in the back of the car. Maybe he can talk to his mom from the back of his car. Instead, he is shouting through a window, okay, is everybody okay? And his mom, who's being held back, is trying to relay information because cops aren't giving it to him. Is that reasonable and understandable under all the circumstances? Yeah, absolutely. Bridget Fournier, while she did come in here and did say something what was really unusual, suddenly he was like, he smelled like pot, right? Well, when the other cops who didn't, necessarily rehearse together, they came in here and said she's nonchalant or he's nonchalant. But she said no pot, and then officers had to come in and say, maybe the pot was a smell out of the bag, but he wasn't reeking of pot. I mean, somewhere along the line, she got wrapped up in a thin blue line with all of these guys because when she was trying to defend this unknown witness okay, Trent Wissington, and what he had seen, Stein was like, shut up. Shut up, okay? The woman on the police force is trying to tell a man that, we maybe ought to look into this further. And I know she wanted to say later that she was just kind of curious if the girls went to the hospital. She was still looking for those witnesses, because she didn't necessarily get it. And the reason is because Daniel said he was T-boned. The evidence at the scene was that he was T-boned, and everybody was saying it was tip to tip, or that Daniel hit the front end of that car. She wanted to know. But somewhere along the line, somebody started to flip her a little bit. Okay? Shay flipped her back. They can do that. But you guys know circumstances exist to make her change her mind, her testimony, make everybody sound believable, make everything sound just so. You guys get to judge that clearly. The bias of police officers with one another is important to know. They don't like to contradict one another. They like to play the game together. And on that night, she tried to get away from the herd and then got pulled back in. But the point of this whole thing is this. It's a bad investigation. You really can't trust anything that Moran did, because all that information that he gave everybody should have been able to vet everything else with statements, measurements, and the car disappeared. Didn't disappear on purpose, maybe? Was it disappeared by mistake? It's not our burden to show you how bad it is. Our burden is not ours, it's theirs. We never had a burden. We were just here to test the evidence. They always had the burden and still have the burden to prove beyond a reasonable doubt that Daniel is guilty of these offenses. Did Daniel drive without a license? We got it. Did Daniel know that maybe his conduct might hurt somebody in another car, they might get injured? But did Daniel understand, did he recklessly disregard a substantial and unjustifiable risk that his consequences would result in Janae's serious physical injury? What we conceded originally. Put away the emotion. Their burden is to prove it.
Objection to the statement of the instruction as regard to knowledge that Janae Edmondson would have been injured.
The game remedy to be instructed by a full amount for you.
Why? Acts recklessly as to causing serious physical injury if the person consciously disregards a substantial and unjustifiable risk that his conduct will result in serious physical injury. Not could, will. So again, Morris comes in here and he's trying to validate everything that Moran said to try and again put information in your guys' mind that Daniel knew that he was going this fast or whatever, I don't know. But again, everything, Morris wasn't there at the scene, right? He wasn't there. He wasn't checking Moran's work. Maybe he should have been. But he wasn't there to check it, so he was relying on what Moran said to come up with his theories, all right? We had to use all of that information to try and figure out what was going on. And again, we're left with what we got. Still their job to prove what he consciously disregarded. Okay? They're trying to say he was going super fast. Maybe Elizabeth Smith was going super fast. Take the emotion out of this. Measure twice, cut once, vet it, and return your verdicts appropriately. Thank you.
Councilman Stady, 16 minutes.
16? Thank you. Ladies and gentlemen, you have to ask yourself, why would Mr. Riley's attorney misquote the instructions on the law?
That's a proper comment on me. She can comment on what the evidence is, what the instructions are.
All right. I took care of that issue, but let's move on.
All right. Focus on what the law is. That's in these instructions, okay? His interpretation of them is not the law. It's what's in the four corners of these instructions, okay? That's important. That's number one, all right? A conscious disregard. Again, here it is. A person acts recklessly as to causing serious physical injury if the person consciously disregards a substantial and unjustifiable risk that his conduct, a risk that his conduct will result in serious physical injury, okay? Consciously disregards a substantial and unjustifiable risk. An alley in a crowded downtown neighborhood and seeing a yield sign and not even reacting in any way, shape, or form, there's absolutely a substantial and unjustifiable risk that your conduct could result in serious
Objection, Your
physical
Honor. Not
injury.
not could, will. Read the instruction.
Everybody stay focused. Let's use the language that's in the instruction.
A risk, a substantial and unjustifiable risk that is conduct. Is it risky to do what he did? Is it risky to other people on the street driving? It was risky. It was risky. Those women, Ms. Smith, Ms. Gorman, they had no idea he was going to come out of there. They had no idea. And I want to be abundantly clear with you both. The fact that their vehicle was the first one to strike him does not mean that they are at fault for what happened next. All right? But for Daniel Riley driving the way he did, consciously disregarding the risk of his behavior, that's why we're here today. Now, Mr. Deemer wants to blame everybody else. And again, remember, this case is about consequences. Every consequence, every action has a consequence, right? Janae has suffered tragic, life-altering consequences because of his actions that night. Okay? Remember that. This is about him. Now, Mr. Deemer, he wants to blame everybody
Your Honor,
under the
it's
sun.
appropriate for her to comment on my argument.
Overruled, you can continue. Have a seat, Mr. Dean.
He blames everybody under the sun. It's the police department's fault. It's, that Officer Moran, when he did the scan, well, the parked car wasn't there. Well, what did he tell you? He said, I did it the next morning, and that car wasn't there anymore. So why would it be in the scan? Okay? Why would it be in the scan? It's a red herring. It's a distraction for you to look over here at all of these other possible, imagined, fabricated problems that the defense wants you to believe. Stay focused on the facts here, all right? I want you also to remember, when the defense talked to you about the white Chevy Malibu, the car that Ms. Smith was driving, do you remember the animation that you saw with that ghost car, the little red car following behind Mr. Riley's car? Adam, can you pull that back up? We're going to watch it again. And do you remember what Mr. Moran told you about this animation? Based on his calculations. Sorry, let me move out of the way. Based on his calculations, based on his scientific methods, that if Daniel Riley was driving the speed limit, he never would have struck that white car. That's even with him violating the yield sign. If he was just going the speed limit, he never would have hit their car. Janae Edmondson would be doing even more amazing things. But because of him and his recklessness, there she sits in her wheelchair. 18 years old, life full. This is science. This is math. When the defendant was asked about if he had a driver's license, pretty sure you remember the testimony. He said, well, yeah, I have one, but I don't have it on me. He lied about having a driver's license. Remember that? He lied. Why would you lie? Because he doesn't want to suffer any consequences. I'm going to show you some more. I'm going to put these photographs back up here for you, because this is really why we're here, okay? Remember in jury selection, when I told you that jury selection, it's a privilege that we have in this country. It's a privilege that you all, citizens from the city of St. Louis, get to hear a case and you get to decide the facts and you get to apply the law, right? It's a privilege. And now it's in your hands, right? You can't do anything about all the other crime in the city, but you can do something about this one. You should do something about this one. I implore you to do something about this
Your
one.
Honor, I'm going to object. This is inappropriate.
Let's move along.
I'm going to show you State's Exhibit 170. That was Janae just hours before she was crushed in between two cars. Just hours before she was hanging on to life by a mere thread. Show State's Exhibit 7, please. Can you zoom that, please? This is where she yet, she doesn't know that she no longer has legs. This was her consequence because of his actions. State's Exhibit 180. This is Janae Edmondson. Janae Edmondson, who should have been out with her friends, going out to eat, playing sports, and living her best life in her last year of high school. She's having to clean her horrific, painful wounds. She's had to endure unimaginable pain. She's had to endure, she told you, those phantom pains where she gets tingling and she thinks she can feel her legs. She's had to have therapy. The cupping and holding where her parents have to touch each one of her legs and say, these are your legs now. These are your legs now. Because her body and her mind can't accept it. This is her reality. These are the consequences she suffered because of his actions. Now, it's important that you send a message to the defendant that he's got to suffer consequences for his actions too. Okay? This isn't a just walk away and forget about it. Well, remember what he said? She lost a leg? Oh, but she's still alive, right? Okay? He needs a reality check. He needs a reality check. Because from what we've heard about his behavior that night, he was entitled, selfish, and reckless young man. And we can't have drivers like that in our city. Take a stand today. Are you going to stand with what's right?
Objection, Your Honor. This is improper.
Keep moving.
Or are you going to stand with the defendant?
I'm going to object, Your Honor. That is improper argument.
Do the right thing. Find him guilty, all 5